Hello.
Hello.
Hello, hello.
Hello, my friends.
Hello.
Hi.
Sorry for the delay, but there was another meeting on our platform.
Hello.
Hello, Susan.
Okay, I'll try to
I have always problem with this.
open my presentation, introduction presentation. One moment.
Nóri, mutasd a gyereket! Láttam! We saw the daughter of Nora.
Yeah.
And I never see her.
Okay, I can't. Moment.
Sorry.
One moment. Oh, something happened. Okay. Maybe this time. Okay. Can you see?
Yeah, yes.
Okay. So I think we are all together. So we can start and we can open officially. So good afternoon. I would like to welcome you and officially open our second seminar. Briefly for our potential guest, my name is Katarzyna Roszewska, and the seminar are conducted as a part of the research project Legal Protection of Children with Disabilities, the Polish-Hungarian Research Platform 2023, organized by the Justice Institute. And today's seminar is entitled Standards of International and National Law in the Protection of Children with Disabilities, Part 2. Presentations will be given by professors from Hungary and from Poland. And we will discuss the following issues: national legal basis for the social security of disabled children in Hungary, the international legal context in the procedural rights of children with disabilities, reflection on the principle of the Convention on the Rights of the Child in Hungarian law, and availability of healthcare services for children with disabilities, national legal basis for the social security of disabled children in Poland, and the principle of accessibility versus the rights of children with disabilities. I hope our seminar will respond, at least in part, to current problems related to the legal protection of children with disabilities. We have 6 speakers in the seminar, so we will start. Please remember to respect the time limit. First to speak is Professor Nora Jakab. Please, Professor, you may begin your speech. Thank you.
Thank you. Just a minute, sorry. Okay, just sorry, I just cannot find the window which I shall share, but maybe now. Can you see it now?
No.
No.
No. Mhm.
We saw the opening.
Only the opening.
Yes. It was. Egy pillanatra bejött Nóri.
Okay, just again. You cannot see, can you? You
No.
cannot.
No.
I'm sorry. Oh, now, okay. So now you can see, I think.
Yes, it's okay. Mhm.
Okay, thank you. I would like to apologize for the delay. Professor Rosewska has introduced me. I'm a full professor at the Faculty of Law and at the University of Miskolc, dealing with labor and social law issues. And I have chosen, as you have seen, the right to social security of disabled children as a research topic. Last time, I've been dealing with the international issues of the benefit or the right to benefit from Social Security based on the Children's Rights Protection Convention or the Children's Rights Convention. And now I decided to turn into the dogmatics of the social rights and Social Security and to have a closer look on the Hungarian situation, on the level of the protection of people in Hungary. Because my main hypothesis, and I think thesis, is that there is no distinction between children and disabled children. And actually, there is no distinction between citizens within the country, because everybody has a right on an equal basis to the right to social security. When we look at it, this is the starting point. And as last time I was referring to some basic principles, now I would like to recall some of them. And you can see that before dealing with social security, we have to look at social rights, which are one of the most controversial areas of human rights, much more complicated than, for example, political rights, and also one of the most variably regulated in different states. And according to some legal literature, social rights are as important a factor in a person's becoming a citizen as classical fundamental rights. And when we are talking about the right to social security of disabled children, I'm absolutely convinced if it's not a life in which you can enjoy your health at a very full level, then it is not really a good life to live. So it's really a sort of quality of your life if you have got access to very good quality of services. Whether is it a fundamental right regarding the social rights, there are formal and substantive requirements which we distinguish regarding fundamental rights. However, we consider as a fundamental right that which the state in question expresses as such in its constitution, which it names as a fundamental right. At the same time, the Declaration of Social Rights, some kind of regulation of social rights, paint a true picture of the value system, the vision of man, the role of a given state, and is generally related to the prevailing political views and, of course, to the narrowly defined conceptions of constitutional law. And the extent to which a community, a society fulfills its duty of solidarity, as I put this phrase into the research plan as well, guided by the spirit of social justice, it says a lot about the quality and moral state of a community or society. But as I have to speed up, I would like to highlight that legislation alone, including the constitutions, cannot produce welfare. It also requires economic development, appropriate fiscal policy, And when we are talking about the right to social security of disabled children, it's really a question of more political branches. The borderline between economic policy decisions, for example, regarding this right of disabled children, and constitutional decisions depends on the constitutionalization of social rights and the quality of the regulation. And the next step of my research is going to be to go into the quality of the regulation regarding the disabled children rights. If the provision of the necessary means of subsistence follows directly from the Constitution and directly from the principle of human dignity, then it is from then on not an economic policy decision whether to provide the necessary means of subsistence to the citizen, but a question of fundamental right, and we can recall it before the Constitutional Court. In the case of social rights, in addition to maintaining these legal and institutional guarantees, additional financial resources must also be made available. And this is one of the most controversial, or I think one of the most controversy compared to the political rights. When we look at the right to social security, it is considered an important component of social rights, as understood in this sense. And it is usually considered as a subsidiary right to the right to work, and it must be asserted when work and the primary income derived from it, or the ability to earn income itself, is temporarily or permanently interrupted, or even permanently terminated due to an unforeseen social and/or economic risk. The right to social security is thus primarily concerned with the question of how, in the event of these social livelihood disruption, and disability belongs to it, the social conditions essential to life can be provided to the individual, and primarily in the form of cash and/or in-kind benefits. So social security is a quality of human life, as I referred to it before, that can be understood in the context of well-being, and it is a question of every disabled children's well-being. Social security is the right of those whose quality of life is generally regarded as acceptable to all. However, since there is no such guarantee in the Constitution for the well-being of the disabled children, the reality is that the sick, the starving, and the disabled, etc., are legally guaranteed a certain existential relief, but they are not guaranteed, they cannot be guaranteed real social security. So, on this dogmatic approach, I have looked on the previous Hungarian constitution regarding the right to social security. And you can see that in this section, which came after the change of the system, so after 1989, the citizens of the Republic of Hungary shall have the right to social security. And the wording is important. In the event of old age, sickness, disability, widowhood, orphanhood, and unemployment through no fault of their own, they shall be entitled to the benefits necessary for their subsistence. And there are social security and system of social institutions which make it real for the citizens. What is it like? We have got very living and very vivid constitutional court practice, which can be divided into different parts. And first, it was said that this section does not give anyone a basic right to social security. Social rights are not a subjective right, but a state responsibility, as we all know that. And it was in this era that it was decided that the extent of the state's commitment was a constitutional responsibility of the government, which was to establish standards with social implications depending on the country's capacity to bear them. Later on, in the constitutional court practice, it was clear that the rule of law legal certainty and the protection of acquired rights and the protection of property provided the basis for the enforcement of social aspects, because it's always a question how to enforce social rights. Later on, within the framework, the legislature may itself determine the means by which it achieves its social policy objective, and it meant the obligation of the state to maintain institutions, which was only laid down in general terms in that section. The legislature has a great deal of freedom to grant subject rights, but also to reorganize or even reduce or withdraw entitlements. Only the depth of the interventions, for example, whether the level of benefits was not reduced below a certain minimum and whether the change did not interfere with other principles of rights protected by the Constitution, could be made constitutional. So the state had a very great freedom how to grant that kind of rights. And under the old constitution, the Constitutional Court has consistently held that that article defined the state function. Then we had a new fundamental law in its 19th article from 2012. There was a total different wording regarding the right to social security in this form, that Hungary shall endeavour to provide social security for all its citizens. And you can see what kind of disruptions emerge. However, Hungarian citizens shall be entitled to the benefits provided for by the law, but not by the state. And you can see that it's not the right to social security which is included, then it's Hungary shall endeavour to provide. Why is this difference? And in this difference, also the social security system regarding the disabled children's social security is also touched. The Constitutional Court decisions talks about a paradigm shift in social policy. And why was it needed? Because referring to the sustainable economic development and the deteriorating demographic situation, the constitutionalists adapted this text of fundamental law because the real possibilities of life recalled that. And the aim was to reduce social security to a state objective, to a state function, and to enforce the philosophy of self-care, and to introduce conditional benefit. There were many criticisms, and there are still many criticisms regarding this fundamental law article. And you can see, for example, the legal problem that there is the erosion of the right to social security. Many claim that the maintenance, the eligibility criteria linked to nationality is contrary to community law. You can also see a sort of taxative leaves in the disruption, the elimination of the designation and content of social security, missing risks, for example, family support, accident benefits, and there are not really place for new risk. However, there are many ways to see that kind of wording. But it's really true that the guarantee of minimum social rights must be backed up by constitutional or legal guarantees, and it cannot be solely a function of budgetary and redistribution policy. But what is really an outcome that we have to distinguish between absolute and relative social security. Among the various definitions of social security, the distinction between these two are widespread among social policy practitioners. And you can see that absolute security is defined as the threshold of subsistence, the creation of security of existence, the guarantee of minimum conditions for subsistence. It is nothing other than the right to minimum subsistence level or subsistence minimum, which is linked to human life and human dignity. However, relative security, by comparison, means the full or partial maintenance of the previous standard living, or the guarantee of this in the case of certain social risk. And the Constitutional Court, as without saying so, only guaranteed the protection of absolute social security But at the same time, the court clearly refrained from guaranteeing in the practice relative social security, stating that social security does not mean that the standard of living once achieved by citizens cannot be reduced as a result of adverse economic conditions. And now we are in a time of adverse economic conditions and even sustainability issues. The definition of Social Security as a state objective under this article of the fundamental law, for example, in my interpretation and also in the interpretation of the author, you can see, can refer to relative Social Security as something the state should only strive for, but not to absolute Social Security, given its close connection with the right to life and human dignity, which it must continue to guarantee unconditionally. So to sum up, it was my aim to have a look on the core of the social security of disabled children and to see what we think of social rights, what we think of the right to social security, and what is the Hungarian approach. And of course, I have taken into account what kind of critics and what kind of favor interpretations exist. But consequently, I really think that it's a very important distinction between absolute and relative social security when we see the wording of any country's constitution. So thank you very much for your kind attention.
Thank you, Professor. That was very interesting, but not optimistic, I think. Now I would like to ask Dr. Zuza Vopera to give her presentation. And Dr. Vopera will talk about the international legal context of the procedural rights of children with disabilities. Doctor, please, you can start.
Thank you so much. I would like to introduce myself. I'm a full professor of law at the University of Miskolc at the Department of Civil Procedure Law. My special research field is, of course, the civil procedure, the special aspects of civil procedures, the judicial cooperation in civil matters in the EU law, and the children's rights. And one of my favorite special field is the family law, of course. So in this time, I will remain at the international context of the participation rights of the children. Procedural rights, the participation rights, and I remain old school, and I have no PPT. So the title of my presentation is that some international legal context of the procedural rights of children with disabilities. So in order for the best interest of children to be effectively taken into account in decisions affecting them, it's important that the children can be involved in the decision-making process. Let me start with a short overview of international legal background participation of disabled children. As I mentioned in my first presentation, the most important document in international legal protection of children's rights is the Convention on the Rights of the Child, hereafter CRC. And the most relevant provisions of the CRC are the Article 2, Article 12, and Article 23 of the Convention. Article 12 establishes the principle that children capable of forming their own view have the right to express those views freely in all matters affecting them. The right to be heard is an important procedural safeguard. According to the Article 2 of the CRC, the child must be guaranteed this right regardless of disability. Other UN conventions also contain provisions relevant to the protection of disabled children's rights. For example, as I mentioned earlier, Article 7 of the Convention on the Rights of the Person with Disabilities, the CRPD, refers specifically to children with disabilities. The European Convention on Human Rights is the Council of Europe cornerstone fundamental rights instrument. While it doesn't make explicit reference to children's rights, its provision apply to children equally because according to Article 1 of the Convention, the rights and freedoms under the Convention must be guaranteed to everyone. And according to the Article 14, They must be guaranteed without discrimination on any ground. So, for example, discrimination on the basis of age is also prohibited. The jurisprudence of the European Court of Human Rights was greatly influenced by CRC. So the provisions of the CRC come into effect in Europe through the jurisprudence or the judicial practice of the European Court of Human Rights. In my presentation, let me first focus on another less well-known convention of the Council of Europe, adopted in 1996, which defines the procedural rights of children. This is the European Convention on the Exercise of Children's Rights, hereinafter ECCR, is a major instrument containing provisions aimed at protecting the best interests of children and promoting their rights, in particular in family proceedings, for example, in custody, access, question, parentage, adoption, legal guardianship. The ICCR entered into force in 2000, and it has been ratified by 20 European countries, only 20 European countries, including Poland. Hungary signed but not ratified this convention. The ECCR provides a number of measures to allow children to exercise their procedural rights. The ECCR essentially complements the CRC. While the CRC establishes the fundamental rights of children, the ECCR detailed the procedural rights of the children. The ECCR doesn't contain any special provision for disabled children. Following, we will examine this issue a little bit more closely. The chapter 2 of the ECCR contains in 3 parts. In part A, names the procedural rights of a child. Article 3 contains the child's right to be informed and to express his or her view in proceeding in accordance with the provision of Article 12 of the CRC. According to Article 3 of the ECCR, now a citation follows, a child considered by internal law as having sufficient understanding in the case of proceedings before a judicial authority affecting him or her shall be granted and shall be entitled to request the following rights: to receive all relevant information, to be consulted and express his or her view, to be informed of the possible consequences of compliance with this view, and the possible consequences of any decision. The Convention specified the modalities of implementation of this right. Children may request to be assisted by a person of their choice, including lawyer. They are entitled to exercise the right of a party to the proceeding, and they have the right to request the appointment of a special representative in case of conflict of interest with their parents. According to the explanatory report of the Convention, Article 3 provides for the exercise of a number of procedural rights which should be given to children unless a child is not considered as having sufficient understanding. Where internal law has not fixed a specific age in order to indicate the age at which children are considered to have sufficient understanding, the judicial or administrative authority will, according to the nature of the case, determine the level of understanding necessary for children to be considered as being capable of forming and expressing their own views. It is worth noting that while the CRC mentioned child capable of forming his or her own view in Article 12, the ECCR refers to a child with sufficient understanding in Article 3, and these are not the same legal category. It is even more interesting that while, according to the CRC general comments, the child capable of forming his or her view is not linked to age, the explanatory report of the ECCR indicates that the state parties can define an age limit above which a child can be considered to have a sufficient level of understanding. I will analyze this question in detail in my first study because it can have a great impact on legal practice and legal interpretation, and of course, from the perspective of the disabled children. So let's go back to the CRC. In the next, I will first examine how to interpret the prohibition of discrimination laid down in Article 2 of the CRC in the case of children with disabilities. According to Article 2 of CRC, the disabled children have the same right as non-disabled children to participate in decisions and issues that affect them. The prohibition of discrimination is a basic principle, of course. EU institutions have adopted a series of directives to combat discrimination, which are also relevant to children. The European Court of Human Rights has developed a substantial body of case law on the prohibition of discrimination under Article 14 of the European Convention on Human Rights. Under EU law, the prohibition of discrimination in Article 21 of the EU Charter of Fundamental Rights is a freestanding principle that also applies to situations not covered by any other charter provision. The grounds of which discrimination is explicitly prohibited in this provision include disability. Article 21 of the Charter extends the field of protection against discrimination to a wide range of new grounds. Moreover, the whole chapter on equality adopts a new concept that go beyond non-discrimination, as for example, the acknowledgement of integration of persons with disabilities. According to the General Comment of Committee on the Rights of the Children, number 14, on the right of the child to have his or her the best interest taken as a primary consideration, this is the title of the General Comment, it is said that the right to the non-discrimination is not a passive obligation, prohibiting all forms of discrimination in the enjoyment of the rights under the CRC. It requires appropriate proactive measures taken by the state to ensure effective equal opportunities for all children to enjoy the right under the Convention. This may require positive measures aimed at redressing the situation of real inequality. According to the General Comment, among the elements to be taken into account when assessing the child's best interest include vulnerability, such as disability. In accordance with the provision of the Charter cited above, the General Comment of the Committee on the Rights of the Children, number 9, the title of the Rights of the Children with Disabilities, Article 2 of the CRC requires state parties to ensure that all children within their jurisdiction enjoy all the rights enshrined in the Convention without discrimination of any kind. This obligation requires state parties to take appropriate measures to prevent all forms of discrimination, including on the ground of disability. This explicit mention of disability as a prohibited ground for discrimination in Article 2 is a unique, or I think that it was unique, and can be explained by the fact that children with disabilities belong to one of the most vulnerable groups of children. It has been therefore felt necessary to mention disability explicitly in the non-discrimination article of the CRC. What does this mean in relation to the Article 12? It means that during the procedure, the disabled child must be given the same opportunity to express his or her view and as his non-disabled peers. However, for this, on the one hand, the legislator must create acts that will have the child with either a mental or physical disability to have the opportunity to express his or her view in the proceeding affecting him or her. This means ensuring that the participation of an appropriate assisting expert. On the other hand, creating a child-friendly, barrier-free children listening room, for example, at the courts. Finally, let me inform you about an English project that researched the right to participation of disabled young people. In 2009 to 2012, as a project was conducted in England that examined the involvement of disabled children and young people in the decision-making process. The name was the VIPER research. VIPER is an acronym. The letters means the voice, inclusion, participation, empowerment, and research. So it was a 3-year project to research young disabled people participation in decision about services. The age of the children was between 0 to 25 years. This research tells us that many disabled young people are still being excluded from participation and decision-making opportunities. Basic access needs to support disabled young people participation are not being met, and children and young people with higher support needs and communication impairment face significant additional barrier to participation. The conclusions of the VIPER project was that while there has been some progress, disabled children are still further behind their non-disabled peer in terms of opportunities to be involved in the decision-making process. Involvement in decisions to be limited to disability issues only and is not typically extended to more general services used by young people. The research found a lack of access and opportunity for disabled young people to be part of mainstream participation activities. So recent years have seen the introduction of significant policy and practice levers that support disabled children participation. But despite these efforts, disabled children and young people have fewer opportunities to participate in decision making than their non-disabled peers. Sorry of my bad news, and thank you for your kind attention.
Okay, Dr. Upera, thank you for sharing your presentation. As I understand, the procedural rights of children, especially children with disabilities, it's quite complex issue. Yes. Last speaker from Hungary is Dr. Marta Benius with presentation on the reflection of the principles of CRC in Hungarian law. Please, Doctor, the floor is yours.
Yes, thank you very much. My name is Marta Benius, and I'm from the Ferenc Medel Institute of Comparative Law. My research field is international human rights law, particularly the rights of the child. And due to the obstacles, technical obstacles, last time I not prepared a PPT, just will speak without it. So I will be speaking as Professor Olszewska said, about the reflection of the principles of the Convention on the Rights of the Child in Hungarian law. In my last presentation, I talked about the 4+1 principles of the UN Convention on the Rights of the Child and its undoubted applicability, but still insufficient implementation as regards children with disabilities. I concluded that the principles underlined are not merely principles in itself, but also rights that cannot be separated from one another and need a comprehensive implementation. The principles provide the interpretative framework of a child rights-based approach. I also concluded that governments and policymakers play a crucial role in establishing comprehensive legislations, policies, and programs that protect and promote the rights of children with disabilities. These policies should align with international human rights standards such as the UNCRC and the UNCRPD and ensure adequate funding and resources to implement inclusive practices effectively. On today's presentation, I would like to shortly present the echoes of these principles of UNCRC in Hungarian law, and to raise the question whether there is a child rights-based approach in general and from the perspective of children with disabilities. The starting point is that Hungary has ratified the UN Convention on the Rights of the Child in 1991, which means that it is incorporated into national law and as such can be directly invoked. Hungary has also ratified the Convention on the Rights of Persons with Disabilities in 2007 and its optional protocol that allows individuals to file complaints to the Committee on the Rights of Persons with Disabilities. The optional protocol that allows the same in terms of the UNCRC is not ratified by Hungary. Before going into detailed analysis, it is worth highlighting that both the CRC Committee in 2020 and the CRPD Committee in 2022, in their concluding observations regarding Hungary, listed the rights of disabled children as an area that raises very serious concerns. So the 4+1 principles we are discussing now is non-discrimination, consideration of the viewpoint of the child, the best interest of the child, the right to survival and development, and the right to live in a loving and caring family environment. I looked at each principle and its reflection on a constitutional level, and then in pieces of legislation on the lower level of legal hierarchy, which might have a direct effect on disabled children. The time limit today does not give a space for going into detailed analysis of every question, so I will rather give an outline of the issues that arise. Nevertheless, I will cover everything in my paper. Besides presenting in brief the legal provisions, I will shortly present the strategy that covers a 10-year-long period from 2015 to 2025. Firstly, let's look at the principle of non-discrimination. There is a general provision in Article 15, paragraph 2 of the Fundamental Law of Hungary that prohibits discrimination on the grounds of disability. Article 15 adds a positive provision saying that by means of separate measures, Hungary shall protect families, children, women, the elderly, and those living with disabilities. Act 125 of 2003 on equal treatment in paragraph 4 says that the obligation of non-discrimination must be respected by persons and institutions providing social care, child protection, and child welfare services. In paragraph 8, it prohibits direct discrimination on the basis of disability, and in paragraph 31, subparagraph 2, calls for the preparation of action plans that covers persons with disabilities. The Act on Equal Treatment does not specify the category of a disabled child. The Act 154 on healthcare appoints the patient rights representative to act against discrimination on the basis of disability. Article 42 specifies the youth healthcare where specific stress is made on minors with disabilities. The CRC committee especially calls for the adoption of laws that fight against the discrimination of children with disabilities and distinguish this category precisely, which is obviously a lack in the legal environment. The next principle to mention is the viewpoint of the child. Unlike, for instance, the Polish constitution, if we look at the constitutional basis of Hungary, we find no direct reference to the respect of the viewpoint of the child or to its evolving capacity to form his or her own views. The participation of children appears in lower sources of law. However, it is indeed a gap and an obstacle for the implementation of a real rights-based approach, as research concludes that positive discriminatory measures are effective when there are measures that allow the participation of those whose discrimination is at stake. So at this point, it's the children with disability. Ensuring the meaningful participation of children with disabilities in decisions that affect their lives is fundamental. Encouraging their active involvement in their educational plans, healthcare decisions, and social activities empowers them to develop self-advocacy skills, build confidence, and shape their own future. Thus, strengthening the principle of participation is the path towards a real child rights-based approach. The next element we should consider is the best interest of the child. The best interest of the child principle does not appear on constitutional level. It might be found in a law incorporating the UNCRC, but with a translation that is mistaken and may misguide the one applying the law. The principle is there with the same translation in the Child Protection Act, Article 2. The principle is there in a slightly different form in the Civil Code in Article 4.2. The best interest of a disabled child as such is not a term that is included specifically in the legislation. The CRPD committee, in its concluding observation, pointed out that Hungary applies the concept of the best interest of the child by giving priority to the opinion of experts and to institutional care rather than involve the child as well, which is an obstacle of a real assessment of their best interest. Let's look at the next element. It's the right to survival and development. Under this principle, we might talk about several aspects. Now, I would like to put the stress on the right to life, the right to development, and the right to education. Article 2 of the Fundamental Law of Hungary says that every human being shall have the right to life and human dignity. The life of a fetus shall be protected from the moment of conception. The right to life from being born alive is guaranteed to everyone, also for children with disabilities. In terms of homicide, the criminal code considers it an aggravating circumstance when the homicide is committed against a person with disability. The Act on Healthcare provides in Article 185 the possibility to terminate the pregnancy until the 24th week of pregnancy on potential disability grounds. Let's see what is there with the right to development. Article 16, paragraph 1 of the Fundamental Law says that every child shall have the right to the protection and care necessary for his or her proper physical, mental, and moral development. Paragraph 3 of the Child Protection Act says that a disabled, chronically ill child has the right to special care that helps her development and the development of her personality. The Act on the Rights of Disabled Persons and Ensuring Their Equal Opportunities in Article 13 specifies that the disabled person has the right to take part in early development and care, preschool education, school education and training, developmental preparation, vocational training, adult education, and higher education as defined in the relevant legislation in accordance with their condition and depending on their age. It also provides for an integrated education of children with disabilities. The Act on National Public Education lays down the details of the right to education, where there is a stress made on integrated education. Nevertheless, the practice shows that there is still a huge implementation gap for children with disabilities. Let's see the next element, which is the right to live in a caring family environment. The right of children with disabilities to live in a family recognizes that family environments provide essential support, care, and nurturing for a child's development. Article L, paragraph 1 of Fundamental Law stresses that Hungary shall protect the institution of marriage as the union of one man and one woman, established by voluntary decision, and that the family as the basis of the survival of the nation. Family ties shall be based on marriage or the relationship between parents and children. Article 4.2 of the Civil Code stresses that the right of children to be abroad in their own family. The right may be restricted only if the best interest of the child justifies it. Even if the separation happens at the end, the child still has the right to maintain contact with birth parents. The Child Protection Act and the policies are adopted in the attitude that separating the child from his or her own family is an ultima ratio measure. The Family Protection Act provides for financial support for those families that are upbringing a child with disability. The CRPD committee pointed out that Hungarian legislation discriminates against children with disability through Article 7 of the Child Protection Act when considering the placement of children under 12 years old in foster families, which exempts children with disabilities requiring higher levels of support, allegedly in their best interests, and thereby perpetuates their institutionalization. There is a lack of access to general community-based services for children with disabilities, including as a consequence of the individual development measure, which results in discrimination against children with disabilities. In terms of children with disability, there is no national strategy in place. There is a strategy that concentrates on persons with disabilities and also considers children. The strategy names children with disability as a group that is extremely endangered. The strategy underlines the importance of early recognition. It says that the key task of the years ahead is to connect the various sub-areas that make up the early intervention process, especially early detection, special education counseling, early development, education and care, as well as care and services affecting the family of the disabled person. The early recognition of disability has a decisive role in terms of a person's quality of life, since the basic condition for intention of personalized development, services, and benefits available to a disabled person is the professional diagnosis of disability as early as possible. This is of particular importance in case of disabled children for whom effective early intervention requires not only a quick and accurate diagnosis, but also the coordinated activities of the health, social, and early childhood education sector. Therefore, the important objective of the period covered by the program is to create the personal and material conditions necessary for establishing an early health diagnosis, to develop related professional protocols, and to create the currently missing connection point of the care system for early detection and early development. As regards early development, education, and training, the strategy highlights that the effectiveness of starting early development decreases thus drastically with the age of child with special educational needs. The primary objective is therefore to ensure that children with special educational needs who are recognized in time and have a diagnosis are included in early development system as early as possible. To this end, a clear demarcation of the health, social, and public education tasks of early intervention, and at the same time creating a connection and harmony between them, especially with regard to the recently transferred professional service system, is a priority task. The strategy rather takes the attitude of a caring model rather than concentrating of providing a childhood to these children by strengthening their access to children's rights and their proper information. To conclude with this brief screening of Hungarian legislation from the point of view of a child rights-based approach, one may conclude that there is still a way ahead to the Hungarian legislator to create, on the one hand, a legal environment that responds on the needs of children with disabilities, which would correspond with the principles of the CRC, and thus allow the assessment from a child rights perspective more easily. And on the other hand, to initiate a rights-based strategy that allows updated data collection, involvement of children with disabilities, and the provision of information to children as well as to their parents, a rights-based impact assessment, and a separated and individuals targeted rights-based mechanism of children with disabilities. Thank you for your kind attention.
Dr. Banyos, thank you very much. I can comment that we envy that you ratified the optional protocol to CRPD at least. And by the way, the discussion on reproductive rights is back in Poland, yes. So now we discuss this issue. We can go to the Polish speakers. And now I would like to invite Professor Wojciech Lis with his presentation, Availability of Healthcare Services for Children with Disabilities. Please, Professor.
Thank you very much. I am a professor at the John Paul II Catholic University of Lublin. In my research, among others, I concentrate on family law. Today's I prepare a topic which is a continuation of previous considerations. But this time focus on the assessment what this accessibility looks like in practice. The basis for healthcare services for children with disabilities are the provisions of the Constitution of the Republic of Poland contained in the Article 68, Section 3, which obliges public authorities to provide special health care, among others, to children and people with disabilities. This guarantee is strengthened in the Article 69, according to which people with disabilities are provided by public authorities in accordance with the Act with assistance in securing existence, adapting to work, and social communication. It should be added that by definition, special healthcare is to go beyond the sphere of ordinary, common, or universal healthcare. So it should be intensified, more specialized, that it is adapted to the specific needs of children with disabilities. If healthcare is to be special, it must fulfill the health interests of disabled children more fully than in the case of other entitled groups. On the normative basis, the constitutional provisions are made more realistic by the Act of 9th of May 2018 on special solutions supporting persons with severe disabilities, which more modifies the rights of children with disabilities in relation to other groups entitled to health care. The Act introduced 3 types of facilitations for those kind of people in the scope of first, the possibility of using healthcare services and pharmaceutical services provided in pharmacies out of turn. Second, the possibility of using specialist outpatient services without a doctor's referral. Third, also abolished the periods of use of medical devices issued to order according to medical indications, which increased the availability of medical devices for people who, due to their health condition, need more medical devices than the limits specified. The need to supply such devices is always decided by a doctor authorized to issue an order. However, the limit of CO financing medical devices from public funds has not changed. These facilitations are undoubtedly needed, but they are limited to people who are over 16 years of age and have a certificate of severe disability. This means that firstly, they do not cover children under the age of 16, and secondly, they do not cover all people with disabilities. People with moderate and light disabilities and people who do not have a certificate of severe disability are excluded from the catalog of entitled persons, of entitled people. This de facto means that the healthcare of children with disabilities does not differ from the care of non-disabled children. It follows that the provisions of the Constitution of the Republic of Poland concerning the provision of special health care to children with disabilities have not been reflected at the level of statutory solutions. In short, the state of the law regarding the rights of children with disabilities in the context of health protection is imperfect. To be fair, it should be added that some facilitations for parents of a disabled child or a child struggling with an incurable disease are also granted by the Act of 4th of November 2016 on support for pregnant women and families for life, which I will skip today. It is even worse with the treatment of people with disabilities, including children, when providing health services. I would like to highlight a few related issues. Improper treatment of people with disabilities who are treated as unable to communicate with a doctor, which prevents them from freely using of healthcare. As a consequence, they are overlooked as dialogue partners. Communication takes place between the doctor and the guardian of a disabled person, who is treated only as an object of influence, as the object of performing subsequent medical procedures on them. Doctors sometimes do not even try to talk to disabled person if they come for a visit with a carer. It should be added that in the case of a disabled child, the decision-making entity is the legal guardian, but the child should be listened to and informed by the doctor in a way that is understandable to him about the actions taken towards him. Condescending treatment by medical staff, allowing the participation of third parties due to the inability to perform examinations or procedures on a disabled patient, is another problem. The medical staff expects the disabled to organize their own support for the time of a medical visit, to come with another person who will know how to deal with them and how to conduct the examination. This approach forces third parties not related to the treatment process to be involved in matters relating to intimate life circumstances, which are undoubtedly visits to the doctor. As a result, people with disabilities are discriminated against because of dependence on others. Inaccessibility of a building and rooms of a medical entity and improper equipment to facilitate examinations or treatments for people with various types of disabilities. This related to the way of placing information in medical entities, marking offices or even toilets. The problem of accessibility is not limited only to infrastructural barriers, but also applies to arranging an appointment with a doctor. Appointments are usually made in person, which is often a serious logistical challenge for a disabled person, or are arranged by telephone. The problem, however, is that the registration staff often do not answer the phone because they serve patients who came in person in this time to make an appointment with a doctor. As a consequence, it forces people with disabilities to make an effort to reach a medical entity to make an appointment in person. It should be added that for people with hearing impairments, telephone methods of making appointments are impossible, while communication with the registration staff on the spot in the medical entity is also problematic due to the lack of a sign language interpreter for some disabled people. Lack of subjective treatment of patients with disabilities, a lack of appropriate equipment and properly prepared staff may result in a resignation from visiting doctors or postponing them, which translates into consequences for their health. It should be added that the consequence of a lack of appropriate competencies on the part of medical staff is sometimes sending patients away or refusing to admit disabled patients. Therefore, it seems necessary in the first place to take action to change the mentality of medical staff, resulting in a change in the treatment of people with disabilities. These expectations are related both to the need to change the way of educating and preparing medical staff to work with people with disabilities, as well as to conduct social campaigns sensitizing people to issues related to disability. It is necessary to improve the process of communication with a disabled patient and to develop communication channels adapted to the needs of people with disabilities. This requires providing medical staff with access to training in communication and dealing with people with disabilities. In order to eliminate signs of inappropriate treatment of people with disabilities, the obligation to ensure infrastructural and communication accessibility of a medical entity should be included in contracts concluded by the payer of health services, which is the National Health Fund. The requirement of accessibility of medical facilities for people with disabilities would guarantee that the health services provided for in the contract will be available to all who need to use them on the same non-discriminatory terms. Thank you for your attention.
Thank you very much. And now about the national legal basis of social security for disabled children in Poland will talk Dr. Paweł Zając. Please, doctor, you can start.
Thank you very much. My name is Paweł Zając. I'm assistant professor at the Faculty of Law and Administration at War Studies University in Warsaw, Poland. Last time, due to the scope of my research and of course the place where I work, I spoke about the legal protection of children with disabilities in the international humanitarian armed conflict law. Today, I would like to change a little bit a point of view and deal with the peacetime and the main task of the state in this time, which is ensuring a social security to all citizens. Professor Nura said that in Hungary there is a right to social security. In Poland, we do not have a right to social security expressis verbis. We have a right to social protection and a little bit of provision from which we can interpret a right to social security. So why my presentation today is divided into the two parts. In the first, which is more sociological and theoretical, the concept of social security in Polish legislation will be briefly explained, which will contribute to a better understanding of the scope of the second part, in which the basis normative acts in the field of ensuring social security of children with disabilities in the Polish legal order will be indicated. In studies of social security, it is often emphasized that defining this concept is a difficult task due to the dynamism of social processes and the evolution of the state. Many eminent representatives of this kind of researchers redefine this concept, extract new content, make further division of social security, create more and more complex and sophisticated concepts. At this point, a question may arise about the purposefulness of such actions. Scientific research, by its very nature, should be aimed at getting to know and understanding the world around us and those at creating mechanisms and instruments that can be used in practice, thanks to which full human development will be possible. Currently, science is characterized by a completely different approach in which a very large role is attached to the theoretical side, which makes different approach in which a very large role is attached to art for art's sake. It's sad, but true. Scientifics create more and more complex definitions which have a major drawback. Due to the extensive content, they can only be applied in the specific cases. Therefore, it should be considered whatever it would not be a better solution to develop one universal definition of social security characterized by abstractness and generality similar to legal provisions. Such actions would allow focusing on the essence of the issue, the practical translation of science into reality. In this respect, one can follow the example of the exact sciences, in which there are certain fixed concepts, thanks to which all scientific effort is focused on the further development of science and not on the constant creation of definition. Following this lead and contributing to further scientific discussion in this area, a new understanding of social security can be proposed that would resist the change taking places in societies and countries. For this purpose, it is necessary to focus on the essence of social security, which is to eliminate threats and ensure human development, because these values will be always remain unchanged. Hence, when attempting a new approach to social security, it can be assumed that these are all manifestations of the activity of the state, society, and individuals aimed at ensuring proper and sustainable human development by eliminating processes, phenomena, and factors that hinder its achievement. Such a broad approach will allow for incorporating into the framework of social security all issues that relate to the uninterrupted functioning of a human being in society, like access to food, housing, clothes, medicine, and education, measures guaranteeing the implementation of the right to live and health. The above definition can be applied to all models of social policy that have been adopted by individual countries, thanks to which social security would become a universal and interdisciplinary field. For issues related to the protection of fundamental human rights are the responsibilities of all nations. Combining the efforts of scientists from around the world will allow the development of the best instruments of ensure human development in accordance with the words of Pasteur: science knows no country, because knowledge belongs to humanity. Thanks to this approach, it is possible to focus on the essence of social security. On the one hand, it will be ensuring security understood in its classical form, and those securing the needs like existence, survival, certainty, stability, identify, independence, protection of the standards of living, and quality of life. In this context, security consists of two closely related concepts: a state of feeling and a process, what means specific action of competent authorities. It leads to the elimination of threats, certain phenomena that have a destructive effect on the state of feeling safe by an individual. Therefore, security is the absence of threats, at circumstances enabling the normal development of the state, the successful implementation of all its goals, usually obtained as a result of organized protection and defense, using forces and resources from all areas of state's activity. However, only such an approach becomes problematic because the states of feeling is a subjective, immeasurable category. Each individual experiences security differently. Therefore, it becomes necessary to standardize the criteria of feeling safe and decenter them. For these purposes, it is necessary to classify security into its individual system, which will determine the norms and standards of safety performance. On the other hand, The essences of social security will be development of the individual and those of entire nation. In this approach, the competence of the state, social groups, and individuals themselves converge. The state will be responsible for creating such living conditions for its citizens, thanks to which they will be able to realize their life aspirations. This will be related to the so-called the minimum standard of living, which defines the limit of expenditures allowing for a decent level of existence, like one in which the basic needs of individuals will be met, like food, clothing, housing, healthcare, education, as well as access to means of communication and local transport, and therefore all means related to the protection of human life and health. The competence of the social groups and individuals should focus on the physio- physiological aspects of development and those created conditions for social acceptance and tolerance. Thanks to them, the individual will be able to follow their aspirations. An important role here is also played by upbringing, thanks to which a person is able to distinguish good from the evil. This issue is related to the system of values that should be passed on the future generations so that while striving for their life ideals, a person is guided by respect for other people while implementing Kant's categorical imperative. In Poland, social security, understood in this way, is firmly anchored in the legal system. The provision of the Chapter 2 of the Polish Constitution concerning the freedoms, right, and obligation of man and citizen are of fundamental importance here. In particular, it concerns the provisions formulated in Article from 65 to 76. The provisions contained therein are to guarantee values that create a social security. Due to the thematic scope of our project, the legal basis for ensuring social security for children with disabilities will be indicated in the following section. Three provisions are fundamental in this area. The first is Article 32, Section 2, which says that no one may be discriminated against in political, social, or economic life for any reasons. The second is Article 68, which defines the basic duties of public authority in the protection of health and the corresponding right of the individual to health protection, which was comprehensively analyzed by Professor Lis. I would only mention it that in paragraph 3 of this article, the legislator states that public authorities are obligated to provide special health care to children, pregnant women, people with disabilities, and the elderly. This particularly means that it should be more fully implement the health interest of the entitled entities than in the case of other entities. In other words, Article 68, Section 3, specifying the content of the duties of public authority in healthcare, limits the legislator's freedom in shaping the healthcare system. The third important provision from the point of view of the analyzed topic is Article 69, according to which people with disabilities are provided by public authorities in accordance with the Act with assistance in securing existence, adapting to work and public communication. The content of these provisions shows that public authorities are primarily to help people with disabilities in securing their existence. This includes to create mechanisms to help meet their basic needs, or more generally, to ensure that people with disabilities are maintained at a level that will enable them to function in a dignified way. As noted by the Constitutional Tribunal of Poland in one of its judgments, the aim of these assistance activities is not to assume the role of the entity bearing full responsibility for creating living conditions for people with disabilities. Public authorities cannot completely resign from taking actions for these people, but the actions taken by them should only perform an auxiliary function, which should be understood as facilitating and providing support to the mere fact of being a disabled person does not mean complete social exclusion. The state should guarantee assistance thanks to which people with disabilities will be able to function in society at least at the minimum level, enabling their existence. However, this does not mean imposing an obligation on public authorities to create a material foundations for the existence of these people to the extent that will meet all their needs. Here, the legislator has full freedom to choose the means to achieve the objective set out in Article 69 of the Constitution of the Republic of Poland. The more so that the regulation, its question contains a very clear reference to the Act, and the rights set out in this provision can only be claimed within the limits set out in the Act. Another acts guaranteeing the rights of children with disabilities are Convention of the Rights of Persons with Disabilities and the Convention of the Rights of the Child, which in Article 23 recognize the rights of a disabled child to live a full and normal life in conditions that guarantee their dignity, enable them to achieve independence, and facilitate their active participation in the society. The ratification of the convention obligates Poland to take special care and provide assistance to children entitled to it and to persons responsibilities for their care. At the statutory level, ensuring children's social security has been broken down in a number of provisions scattered in various normative acts, among which we can mention it, the Act of Social Assistance, on the educational system, on sign language and other means of communication, on the ombudsman for children, on establishing and payment of benefits for cares or family benefits. An important act, although not having the value of universally binding law, is also the Charter of Rights of Persons with Disabilities, adopted in the form of resolution by the Polish Parliament, in the light of which the people with disability have the right to an independent, self-reliant, and active life and may not be subject to discrimination. They have the right to full access to goods and services and comprehensive rehabilitation, the right to education, pedagogical assistance, and other guarantees and social securities. A detailed analysis of the above normative acts will be the subject of the further research within this project. To sum up, the Polish legislator has adopted a number of normative acts in which it regulates the provisions of social security to children with disabilities, understood mainly as guaranteeing appropriate legal mechanism thanks to which each child will be able to lead a life in an undisturbed manner at a level that allows him to achieve both aspiration, material and spiritual. Thank you very much.
Thank you very much for your broad presentation of social security. Thank you. And now it's my turn. My name is Katarzyna Ruszewska and I'm assistant professor and lecturer at Cardinal Stefan Wyszyński University in Warsaw at Department of Law and Administration. I deal with social law, labor law, and the rights of persons with disabilities. And 1 second, I try to share my presentation. Okay, can you see? It's okay, can you see?
Yes.
Okay. So one moment, because I need to check how to change these slides. Okay, so the topic of my presentation today is the principle of accessibility versus the rights of children with disabilities. In part 1, as you remember, my topic was about general accessibility as a principle of international law, and I tried to present the origins of accessibility in international law and show 2 ways of developing the contemporary model of human rights. I present, for example, the struggle of Black community, exactly of parents for access to education, because later they were followed by parents of children segregated on the basis of disability in schools. I also showed 2 successful men in disciplines not obvious to people with disabilities, because in sport and science. And these examples showed the importance of accessibility even before we started discussing this as a principle of international law. And I also showed 2 paths of development of the rights of people with disabilities and mentioned several historical acts. I put a lot of attention on development of legislation in the United States because it gave rise to accessibility standards. But when it comes to international law, first in soft documents and finally in the CRPD, accessibility has become a principle of international law. And there is no doubt that a person with disabilities can lead a normal and successful life. How we support children and youth in education affects the development opportunities in all areas of life, professional development, social security, social activity, and even a potential career. In this part, I will try to indicate selected international regulations regarding accessibility, especially for children with disabilities. Children with disabilities are now recognized under international law as rights holders without discrimination and on the basis of equal opportunities. But we have walked the long path from the 1924 Declaration to the 1989 Convention on the Rights of the Child. The first declaration articulated that all people owe children, for example, the right to means for their development, special help, economic freedom, and protection from exploitation, regardless of race, nationality, or creed. Declaration from 1959 developed these provisions and declared that every child is entitled to all the rights without discrimination, for example, on account of race, color, sex, language, and so on. And additionally, special treatment, education, and care for children with disabilities, it was stated in Principle 5. When we know that accessibility was the next step in the development of the right to equal treatment and non-discrimination, it should be recalled that disability as a ground of discrimination had not yet been explicitly mentioned at the time. The grounds for discrimination were skin, color, race, religion, and so on, but not disability. And I'm not sure if you know that the proposal for Convention on the Rights of the Child presented at the session of the UN Commission on Human Rights in 1978, it was a Polish proposal. The chairperson of the working group was Adam Łopatka, and he was the chairperson for the whole drafting process. Since disability was regarded as a social welfare issue, the earlier human rights treaties did not contain provisions on the right of persons with disabilities. These treaties made, of course, references to disability by recognizing the right to security in the case of sickness or disability. And of course, they are relevant to children with disabilities since they contain rights that are supposed to be enjoyed by all persons, including children. The first sources of accessibility requirements for children in various areas of life are general comment to the UN treaties, for example, General Comment number 5 on persons with disabilities, to the International Covenant on Economic, Social and Cultural Rights. Earlier references in soft law can be found in Programme of Action Concerning Disabled Persons of 1982, and of course in Standard Rules on the Equalization of Opportunities for Persons with Disabilities of 1993. And then, of course, the CRC and, most of all, the Convention on the Rights of Persons with Disabilities. I think it's worth highlighting what we already know, that CRC was the first human rights treaty that contained a specific reference to disability in Article 2 on non-discrimination, and in Article 23 exclusively dedicated to the rights of children with disabilities. Now, according to Article 2 of the CRC, states shall respect and ensure the rights set forth in the Convention to every child without any discrimination on the grounds set out in the Convention. And disability is clearly mentioned among them, as I said. So it has formally become the basis for possible discrimination in international treaties. When it comes to Article 23, states recognize that mentally or physically disabled child should enjoy a full and decent life in conditions which ensure self-reliance and active participation in the community. This emphasized the need to create specific conditions, so take positive action that were to ensure a full and decent life. And this provisions also states that assistance shall be provided free of charge whenever possible, ensure an effective access exactly to education, training, health, care and rehabilitation services, preparation for employment and recreation opportunities in a manner conducive to the social integration and individual development. A separate general comment number 9 is devoted to children with disabilities, and it estimated that there are 150 million children with disabilities in the world. Most causes of disability, such as war, disease, and poverty, are preventable, so most of which we could avoid. Also, the secondary effects of disability can be reduced by early intervention, but more than 80% children with disabilities live in developing countries with little or no access to services. Discrimination excludes them from education and denies them access to quality health and social services, and the lack of appropriate education and vocational training, of course, deny them job opportunities in the future. Human rights treaties and human rights treaty bodies have, of course, considerable potential to promote the rights of children with disabilities, but generally they were not fully exploited. So children with disabilities are still facing barriers to the full enjoyment of their rights. The committee of CRC, emphasized that the barrier is not disability itself, but rather a combination of social, cultural, attitudinal, and physical obstacles. Nowadays, thanks to the Convention on the Rights of Persons with Disabilities, respect for the rights of children with disabilities is one of international principles, exactly respect for the capacities of children with disabilities and for the right to preserve their identities. And in Article number 7, dedicated to children, we can read that state shall take all necessary measures to ensure the enjoyment by children of all human rights and fundamental freedoms on an equal basis with other children. States shall ensure that children with disabilities have the right to express their views freely on all matters affecting them, and their view will be treated in accordance with their age and maturity, and they will be provided with assistance in realizing this right in accordance with their age and disability. And now a few examples of particular rights and access to these rights. Poverty being a cause and consequence of disability is still heavily exposed. The children with disabilities and their families have the right to an adequate standards of living, and the question of children with disabilities living in poverty should be addressed by allocating adequate budgetary resources and by ensuring that children have access to social protection. One of the most prominent rights of children is, of course, the right to education. Children with disabilities have the same right to education as all other children and shall enjoy this right without any discrimination and on the basis of equal opportunity. For this purpose, effective access of children with disabilities to education should be ensured, and accessibility is required in both public and private institutions at all levels, vocational training and lifelong learning, and in all aspects, even in extracurricular and social activities. Already the Convention recognizes the need for modification to school practices and for training of regular teachers to prepare them to teach children with disabilities. Of course, the right to education is very extensive, and we'll discuss them in our future seminars. But in terms of accessibility, it's worth paying attention to its elements. Accessibility of schools includes, for example, universal design schools and other educational buildings, facilities like playgrounds, libraries, spaces for recreation, sports, canteens, toilets, and sport too from school and on excursion. Curricula conducted in national sign languages, Braille, alternative scripts, augmentative, alternative modes, means, and formats of communication. Appropriate and accessible teaching materials, assistive device, accessible information and communication technologies, personal assistance even, and of course trained teachers and other staff. Also accessible curricula and materials for teachers with disabilities, because states must support the recruitment of teachers with disabilities and remove any legislative or policy barriers requiring candidates to fulfill medical criteria. Their presence will promote equal rights of children with disabilities, bring unique expertise and skills, and will contribute to breaking down barriers. And basic education, of course, sometimes it's only primary, sometimes also secondary schools. It depends on the countries. But basic education should be provided free of cost and in the communities where the children live. Alternatively, it must be accessible through information and communications technologies, but however, states should avoid relying exclusively on technology. The next example of regulating the law, taking into account accessibility, is the right to healthcare. Access and affordability of quality healthcare is an inherent right for all children. Children with disabilities are often left out because of inaccessibility, the lack of information and financial resources, transportation, even geographic distribution and physical access to healthcare facilities. Very often, disability is detected quite late, which deprives the child of effective treatment and rehabilitation. Health policies should be comprehensive and address early detection of disabilities, early intervention, including psychological treatment, rehabilitation, physical aids, for example, limb prostheses, mobility devices, hearing, and visual aids. And early identification requires high awareness among health professionals, parents, and teachers. They should be able to identify the earliest signs of disability and make the appropriate referrals for diagnosis and management. Therefore, systems for early identification and early intervention within health services are essential, and services should be provided in the community as well, even at home. Links should be established between early intervention services, preschools, or schools to facilitate a smooth transition for the child. Next problem is institutionalization. Too many persons with disabilities live in long-term institutional care, also children. Children with disabilities, as well as children living with parents or other caregivers with disabilities, should receive the support that would protect fully their rights and allow them to continue to live with the family. Support includes, for example, material supports in the form of special allowance and supplies, necessary equipment, such as special furniture even and mobility devices, services such as different forms of respite care, care assistance in the home and daycare facilities, accessibility at community level. Such services enable parents to work as well as maintain healthy family environment. Another area where attention is paid to accessibility is culture, recreation, and leisure and sport. It's pointed that an equal access with other children to participation in play, recreation, leisure, and sporting activities, including those activities in the school systems, access to information and to culture, literary and artistic works, sometimes is denied in several states by copyright laws that hinder the availability in accessible and alternative formats of such works. So the CRPD and CLC committees recommended to sign the Marrakesh Treaty. Full name is the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise pre-disabled. The role of rest, leisure, recreation, cultural life, and the arts is essential to a child's development, as we can read in, for example, the general comment to CLC on the right of the child to play. Not so obvious at first glance is access to birth registration system. Children with disabilities are vulnerable to non-registration at birth. Without registration, they are not recognized by law and become invisible in government statistics. Children who are not registered at birth are at greater risk of neglect, institutionalization, and even death. Non-registration has profound consequences for access to social and health services and, of course, to education. And why are they denied registration? I think maybe this has an impact on infant mortality statistics. The last example in terms of accessibility for children with disabilities is the access to human rights institution. The children with disabilities must have the access to a functional complaint mechanism. National human rights institutions can take many shapes or forms, such as an ombudsman or a commissioner, and may be broad-based or specific. Whatever mechanism is chosen, it must be independent and provided with adequate human and financial resources, well known to children with disabilities and their caregivers, of course, accessible not only in the physical sense, but also in a way that allows children with disabilities to send complaints or issues easily and confidentially. And this institution must have the appropriate legal authority to receive, investigate, and address the complaints of children with disabilities in a manner sensitive to both their childhood and, of course, their disabilities. And a bit of different issue, not related to a specific right, although originally based on the right to education, because based on the recommendations of the Committee on Economic, Social and Cultural Rights for Education Systems, but also relevant, I think, to other areas, that three elements related to accessibility have been distinguished. There are availability, acceptability, and adaptability. Availability means public, private institutions and programs must be available in sufficient quantity and quality. Acceptability means the obligation to design and implement all facilities, goods and services with full respect for the requirements of the culture, views and languages of children with disabilities. The form and content must be acceptable to all. And adaptability, it's the universal design, a set of principles providing specialists and other staff with a structure to create adaptable, flexible environments that meet the needs of all children. Now coming to the conclusions, accessibility in relation to children's rights first appeared in international soft law and in general comments to the human rights treaties. Then it was regulated in a binding and most detailed way in the CRPD as a principle of this act and in the content of particular rights. In terms of accessibility, Article 9 is closely linked to several other articles which I mentioned. Accessibility is a precondition for the full and equal participation of children with disabilities in society. The accessibility services provide children, in particular those with psychosocial or intellectual impairments, with an opportunity to express their will and preferences, support them in exercising their legal capacity, and reduces the future need for support. The physical inaccessibility of public transportation, governmental buildings, recreational facilities, among others, is a major factor in the marginalization of children with disabilities and compromises their access to services, including health, especially, and education. So all new public buildings should comply with specifications for access of persons with disabilities. These existing buildings and facilities should undergo alteration that make them accessible. And also access to information and means of communication, including information and communication technologies and systems, enables children with disabilities to live independently and participate fully in all aspects of life. This RPD has not only made accessibility a binding commitment, it has developed it for facilities and services open or provided to the public. So the convention requires the implementation of minimum standards for the accessibility and to ensure that private, especially not only public but private entities that offer facilities and services to the public take into account all aspects of accessibility. This act also lists in detail the various areas, forms and means of accessibility. For example, it points to sign languages, braille, alternative and augmentative communication, information and communication technologies, personal assistance, even guide dog and so on. And finally, accessibility is a dynamic concept. So therefore, state must ensure that the rapid development of innovations and new technologies are accessible to all children. And state must invest in the development of innovation and new technologies of accessibility standards and make accessibility a central aspect of procurement. Thank you for your attention, and that's all on my end. Thank you very much. Thank you for your presentation also. I think we've been talking longer than the last time, and our time is finished, but if there are any questions or comments, please don't hesitate. So if not, I'd like to pass maybe some information. I remind you to send the original attachments. I sent emails, as you remember, attachment 3 and 4 to the Institute. And our next seminar is July 13th. Now, because the end of academic year is coming, so I wish you a wonderful holiday, but please remember that we are working on our monograph, so don't forget this, and all the best for you. And
Thank you so much.
See you soon.
Have a nice
you very much.
holiday.
Thank
See you
you.
soon.
See you.
Bye.
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 Bye.